I'm super excited to know that we've got a bunch of people here joining us via Zoom. We also have a bunch of people apparently in a room somewhere in Kansas City because I know the Freelance Exchange is hosting an event this morning and they're actually broadcasting me. So I'm assuming my head's like on some big screen TV or something. So let's get going. Why me? Well, my name's Chris Brown. If you don't already know me, I own my own law firm. It's called Pixel Law. And I work with freelancers on a regular basis. I do contracts, I do trademarks, I do LLCs, I do all of that stuff. I do a lot of work with copyrights, trademarks, and intellectual property, basically all of the topics that you are likely to run into as a creative professional. I live in Boulder, Colorado now. I used to live in Kansas City. I spent most of my life in Kansas City, but about 2 years ago, we decided to relocate to Colorado. I am expanding my firm here, but 90, maybe 95% of my clients are still in Kansas City. So I'm super connected to Kansas City and I always will be. I'll be back there next week, of course, for Thanksgiving. So I'm definitely not leaving Kansas City entirely. But in either event, I love giving these virtual conversations. What I really hate about these virtual sessions is that the Q&A and the interaction with you is a lot more difficult. So here's what I want you to do. Put your questions in the chat. I keep saying chatbot. My mind is on GPT. Put your questions in the Q&A feature down there in Zoom. You can use the chat if you want to, but I really prefer that you put the questions in the Q&A so that I can mark them off as I resolve them. And I'm going to try to get to as many questions as I can. I already see questions coming in. It's really hard to get to every question, but I'm going to try to pick out the ones that are the most useful to the most people. All right, so why contracts, right? You're not going to be surprised to learn that I, as a lawyer, love contracts. But seriously, I think that they can provide tons of value to you. They help you and the other party to upfront figure out what all of the issues are about your project, whether it's payment or services or indemnification or insurance, whatever. It really helps you on the other side to figure out what the deal is, what the project is, right? And then if a dispute arises, the contract, if it's done properly, can help you and the other side to resolve that dispute. You can maybe avoid court. You can maybe use arbitration if you have an arbitration provision. And even if you end up in court, it can help you on the other side speed up that dispute resolution because maybe you can have a governing law provision or a jurisdiction provision or an insurance provision or whatever it might be to speed that up. So contracts are extremely beneficial. And I very rarely would I say don't use one. If nothing else, use a written, an email exchange. But you should almost always use some kind of a contract when you're working with other people. So then the first question that comes up is, what is a contract? And you might be surprised to learn that it only takes three things. One is an offer, two is acceptance, and three is what lawyers call consideration, which is just something of value going between the parties. So if I say, I'll build you a website for $5,000, you say, okay, great. We have a contract. You can enforce it in court. I have to build the website. You have to pay me $5,000. I offered, you accepted. And the consideration, the thing of value, for you, it's paying me $5,000. For me, it's building you a website. That right there is all you need. It doesn't have to be in writing. But like I mentioned a minute ago, it's usually a good idea to put it in writing, if nothing else, like an email exchange, so you have some documentation of what the actual agreement is between the parties. Well, that's not working. There we go. Okay, so the two most common formats that you're the two most common contracts that you're likely to encounter are client agreements and contractor agreements. Client agreement, of course, is between you and a client. Contractor agreement is, of course, between you and somebody that you're hiring to provide services to you. It can be they're helping you build out your own website, or it can be that they're helping you build out a website for your client. I keep noticing that my video is having an issue. The internet in my building today has been a little bit weird. If I turn off my video, don't worry, I'll still keep talking, but I'm going to keep it on unless it completely freezes. Anyway, so the contractor agreement can be for somebody that's helping you or helping you help your client. In that case, they would be a subcontractor, but in either event, the agreement remains the same. It's a contractor agreement. Now, you have two overriding formats that you can choose from. The first is a single agreement format, which is you do one project for the client, they pay you, you're done, right? Or what you will probably see more often is the MSA and SOW format. What that is you have an MSA that governs the legal terms. So ownership of IP, confidentiality, governing law, all that legal stuff that as a non-lawyer, you probably don't want to deal with very much. And then you have one or more SOWs that govern the project specific terms for whatever that project is. So you might sign an MSA, and then you sign SOW1 to do a marketing strategy for your client. You get done with a marketing strategy, you come back and the client says, okay, I want you to build my website. So SOW number 2 might be a website development agreement, right? At the end of the website build, maybe you say, okay, now I can maintain it for you and I'll charge $100 a month. So you might do an SOW number 3 that is a 12-month agreement where they pay you $100 a month and you just update their plugins, right? The idea is you have as many SOWs as you want governed by the MSA, so that you don't have to constantly be renegotiating the legal terms. Instead, you're just focusing on the project-specific deliverables. And it's a great way to maybe use a lawyer to do the MSA, but maybe you don't need a lawyer to do each SOW because you may not really be dealing with legal issues. It might be more about just what are you doing and what are they paying you. Wow, my arrows just don't work today. Okay. I mentioned this a couple of minutes ago. If you have questions, put them in the Q&A window. I'm going to be covering a lot of ground. In fact, this presentation used to include a lot of other stuff. But what I decided to do this time is really contain it down to just more or less the essential contract terms. I actually stripped out a whole bunch of stuff because I realized I wasn't getting through all of it. And I really wanted to focus on the contract terms and the language that can help you the most. So I'm going to go through, I don't know, 7 or 8 7 different provisions that you're going to need to have in your contracts. And there's more than this, but these are the ones that are the most essential to you. So what I want you to do is ask your questions in the moment while we're in those sections. You can ask them later, but it's usually easiest if we deal with them right then and there. So I already see there's a bunch of questions coming in. I'm going to quickly skim through those to see if I should answer any of those now. There's a question about insurance. I'll probably come back to that. Oh, there's a question about what I was doing in the ChatGPT. Somebody had asked about rights of publicity, so I put that in the chat bot thing that I had created to answer. Trademarks, I'll come back to that. Okay, here's a very relevant one. Somebody said, I know what SOWs are, but what does MSA stand for? That's a great question. MSAs are the Master Services Agreement, and the SOW is a statement of work, sometimes called a scope of work. Okay, I'm going to keep moving forward. Let's talk about parties. This is the very first essential term. So this is kind of like the overriding most important thing you need to keep in mind is who is the party to the agreement. You put this in 2 places. First, you put it at the top of the agreement in the preamble. This is the where you say like this client agreement is between Newco and Bob, right? That's where you list out the party names. And if you are an individual, so if I'm signing a contract under my own name, I would put my name, Chris Brown. This client agreement is between Chris Brown and client. If you are an LLC or some other type of business entity, don't put your individual name there. Don't say this client agreement is between Chris Brown on behalf of his company or something like that. Just say this client agreement is between Pixel Law LLC and the other client, right? Don't put your name. If you put your name, it might mean that you individually are the party to the agreement, and that's probably not your intent, right? The second place you put it is in the signature block, and I'm going to show you what that looks like here. So you can actually screenshot these if you want. I'm going to send all this out in an email later, but feel free to screenshot any of these slides if you want to refer back to them later. So this is the second place where you put the party name. And like I said a second ago, if you're signing it under your own individual name, it's really easy. Just sign your name and print your name, right? So for me, Chris Brown, that's simple. But if you're signing the contract on behalf of a business entity, don't do it like that. Do not at all do that. Use the format that's on the right, which is for businesses. In that case, you would put Brown Enterprises, LLC, which is just a fake company. You sign your name, you print your name, and you print your title. And I don't really care what your title is. It can be owner, founder, CEO, CFO, managing member, whatever. I mean, you should use the right title. But what really matters here is that you've got the company name first, followed by you signing the agreement on behalf of the company. And really, that's the only place that your name, individual name, should show up in the agreement if you're signing an agreement on behalf of a company. Don't put your name anywhere else. Throughout the entire agreement, you should refer to your company as Brown Enterprises, or if you define it as company or client, that's fine too. but you really want to use this format to make sure that you as an individual don't somehow wind up as a party to the agreement. All right. Moving forward, we're going to talk about services. So I actually ran into this problem just a couple of weeks ago, and I see this problem a lot where you have a website that says that somebody will build a web, or not a website. You'll have a contract that says somebody will build a website for somebody else. In this case, Gene will build a website for Bob. That's not good enough. What happens if Gene builds a one-page Wix website and hands it over to Bob, and Bob is supposed to pay $5,000 for that? And Bob says, no. I was expecting a 20-page website and, a plugin here and there and contact forms and all that stuff. And Gene says, well, I built you a website. So that's clearly not good enough. And Bob might say, well, we've got all these emails, all this communication that says all the things you're going to do in the website. And Gene will say, well, I don't care, because this agreement has an entire agreement provision, which most agreements have, that says that the entire agreement is contained in those four corners of that document. So Gene did his job. He built a website, right? Now, Bob might sue him or do all these other things, but Bob doesn't want to be in that situation. So what you want to do when you're just defining the services in an agreement, whether you're the one providing the services or somebody's providing services for you, is be as clear as you can possibly be. You want to avoid ambiguity. Ambiguity exists when a provision has multiple meanings. And that's a no-no. You don't want that. You can have vagueness. Vagueness is when it's just not as clear as you want it to be, but it doesn't necessarily have alternate meanings, right? So vagueness is sometimes okay, but ambiguity is never okay. So be as clear as possible. How many pages are you building? How many different page formats are you going to build? What plugins are you going to use? Who's going to pay for those plugins? Are you using Wix or WordPress or something else? If you're buying a theme, who's going to pay for the theme and which theme are you going to use? All of those considerations should be put into the scope of work, whether it's a statement of work, scope of work, an exhibit, whatever. List all of that stuff in the agreement. If it's not in the agreement, it's probably not enforceable. If there's timeframes involved, then make sure you reference those. If you sign this agreement, or if Gene and Bob sign this agreement and Gene delivers the website in 6 months, was that Bob's intent, or was he expecting to have it in 30 days? Right? What about milestones? Maybe you'll have milestones where you say milestone 1 will be wireframing, milestone 2 will be the initial development, and milestone 3 will be the final tweaks to the website or whatever it might be. Those milestones and timeframes are really important, especially if you're the one who's paying for the work to be done. And then the last thing here is make sure you say what's excluded if there are things that are going to be excluded. So in this case, Gene might exclude website hosting. He might exclude the purchasing of the domain name. He might exclude complex plugins or something like that. If it's something you want to pull out of the agreement and make not part of the agreement, then just make it clear that that's not covered by the agreement. Okay, I've got somebody asked the question about contractor executing the work for your company. I think I know where you're going with this. Let me see if I can slide back here. I mentioned earlier that there's client agreements and contractor agreements. So on the one hand, you might have an agreement over here between you and a client that says you're going to build the client a website. And then over here, you might say, well, this is a real example. I think Julie might be in the audience with the freelancer people. Let's say that I'm going to build a website for somebody, and then I'm going to go hire Julie to write the content, copywriting for that website. So I've got my client agreement between me and the client over here. And then I have a subcontractor agreement between me and Julie over here. Now, what happens there is Julie and the client are on opposite sides of that deal, right? They don't really have any rights against each other. Rather, the client has a right against me, and I have a right against Julie. So if Julie doesn't write the content, the client, and so I don't deliver it to the client can sue me, and I can sue Julie, right? Realistically, you're probably not going to get in a lawsuit, but that's how the chain works. It's client to me to contractor. If you want Julie to contract directly with the client, that's fine, depending on the circumstances. But in that case, I would have my contract with the client, and Julie would have her contract with the client, right? And I'm actually not a part of that. What most people would prefer to do is have those people serve as subcontractors. Now, it creates risk for you because if Julie doesn't deliver to you, you can't deliver to your client. But that's why you want to make sure the client agreement and the subcontractor agreement align and give you the ability to enforce your rights against Julie. Okay, let's move on to payment. This is where I'm going to first start getting into some sample language for you. Oh, jumped ahead. All right. So in that same example I just gave, Bob will pay Gene $2,000. Again, not good enough. When is that payment due? Is there a non-refundable down payment that's due? Is it due up front, due at the end, due over milestones, or whatever it is? You need to make it very clear how that's due. And if there's processes like invoicing and net 30 terms, net 30 just means you'll pay the invoice 30 days after you get it, right? You need to make sure all of that stuff is clearly defined in the agreement. Most commonly, you'll see something like Bob will pay Gene, say $1,000 at when you sign the agreement, and then the last thousand is due when the website is delivered to Bob, right? And then think about refundable payments. So a lot of freelancers will choose to have non-refundable deposits, which is a good idea to protect you, to make sure you at least get some money in the bank if your client decides not to keep working with you. So in this case, $1,000 would be payable up front and non-refundable. And then if Bob just disappears after the first month, you could sue him. You can go after him for the money, I suppose. But if nothing else, at least you have $1,000 in the bank, and that's better than being left with nothing, right? And then also think about reimbursable expenses. So I mentioned earlier, like plugins or website themes and who's going to pay for that. Always include that in your agreement. If Gene wants Bob to pay him back for the $150 WordPress theme and the $20 plugin and the $50 that he spent on stock photos or whatever it is, then Gene needs to put that in the agreement. Because if he doesn't put it in there, Bob won't have to pay it. It's just kind of presumed that the $2,000 is the fixed fee that is due. So always consider those reimbursable expenses. And if you don't want to include them as reimbursable expenses, you can just increase your fee. Just say $3,000 instead, and all those expenses are then covered by that. All right, let's look at some sample language here. So there's actually two different provisions here. One is hourly and one is fixed fee. And again, you feel free to screenshot these. These are really basic and simple, and I think they would work for you in a lot of scenarios. The first one is the contractor is just going to charge $75 an hour. So in that scenario, the contractor is going to deliver invoices to the client. The client will pay all undisputed amounts owed in each invoice within 30 days of receipt. Now, if you're the one who's making the payments, so maybe it's a contractor agreement, you want to really focus on this days of receipt thing. Sometimes you'll see the contractor say it's that you have to pay them within 30 days of the date of the invoice. But as the party paying, you don't care what the invoice date is. What if I send you an invoice today and I date it, 2 weeks ago? So all of a sudden your payment term is 15 days instead of 30, right? What you want is 30 days of receipt of the invoice. Next up is fixed fees. And this is a really good format that I love using with clients. It's pretty straightforward. The fixed fee is $5,000 broken up into these payments. And a certain amount is due when you sign the agreement plus 2 other milestones. And those milestones are actually, in this case, tied to dates. But you can also use phases, and phases, milestones, same thing. So maybe instead of $1,000 on or before January 1st, it's $1,000 upon the contractor's completion of phase 1. And if you do that, you want to make sure that the services, the scope of work, clearly defines what is phase 1 and phase 2 and phase 3 and so on, right? And either one of these work. These are just really simple provisions that I think you can totally use in most of your freelance contracts. Okay. That's all I have on payment and services. Does anybody have any questions on those before I keep moving forward? I'm going to scan back through the questions here. Let's see here. So somebody asked the question about contracting with a minor, or that some of the work might be done with somebody who's under 18. Generally speaking, you can sign a contract with a minor, and it's sometimes enforceable, sometimes not. Like if you are going to sell a car for $50,000 and a 7-year-old signs the agreement, I've got an 8-year-old. So let's say my 8-year-old Abby signs a contract with you to buy a car for $50,000, and Abby, my daughter Abby, doesn't pay you. Good luck enforcing that. That's not happening. But let's say that you sign a contract with a 17-year-old to do, 5 hours of services, helping you build out a WordPress website or something. It's probably going to be enforceable under those circumstances because it's you're not really taking advantage of the minor, right? But even so, it's almost always a good idea to work with the parents or the guardians of that minor and have them sign the agreement also, so that you've got both the kid and the parent or the guardian signing the agreement to ensure it's enforceable. Because in theory, any kid could get out of any contract, but you might be able to enforce it depending on the very specific situation that you're in. Otherwise, I would definitely try to work with the parent or guardian. How or can you add on late fees to payments if they are not paid within 30 days of receipt? Oh, that's a great question. So if I bounce back to that payment section, I would usually just have a provision that says the client will pay you, or whoever it is, the other party will pay you 1.5% interest per month on any amounts that are past due. And 1.5% per month is a pretty standard number. Sometimes you see it represented as 18% per year, which is the same thing. In either event, do it that way. Don't call it a late fee, and certainly do not call it a penalty. Courts do not like to enforce penalties against people in commercial settings, but they will enforce something like it's called liquidated damages. But if you want to call it a late fee, that's probably okay. But I would avoid calling it a penalty. So in that case, just say that the client will pay you 1.5% interest per month for any overdue amounts under the agreement or something along those lines. Okay. What if a task isn't written in the SOW, but the customer randomly asks you to do it? What should you do? Okay, great question. This goes back to the services section. I'm not going to bounce back there on the slides, but if you have a SOW and it says you're going to do these things, 5 different things, and the client comes back and says, okay, I want you to actually do this other thing. What you should do is sign another statement of work to cover the extra work, or amend the current SOW to add that back in there. Now, if you're doing a $20,000 project and the client asks you to do an extra $500 of work, just assess the risk. If they're a good client and you're not worried about it, you might just do it and invoice them for it and hope everything works out okay. But if it's a $20,000 SOW and they ask you to add on another $15,000 of services, don't just have a handshake. Do an addendum or an amendment to the SOW, or just sign a whole nother SOW to cover the extra work. You really don't want to take on too much risk, but it's always about identifying how much risk is involved in that particular deal. Okay, now I'm going to move on to intellectual property. I saw some questions come through about trademarks, and I think this will probably answer them. So intellectual property is a very broad area of the law, and it covers things that are just intangible, things that you cannot hold. If I have this phone here, I can hold it, I can sell it, and if you give me money, I give you the phone, and you physically hold the phone. It's easy, it's obvious. But intellectual property is a lot more confusing, because if I sell you a copyright, there's nothing physical for you to hold on to. So it's a little bit harder to comprehend. Anyway, there are 4 different types of IP. There's patents, which protect mainly inventions and processes, which are probably mostly irrelevant to you guys. There's trade secrets that I'll come back to later. The trade secret laws protect confidential information and under the act, what they define as a trade secret. But I'll come back to that in a few minutes. Trademarks probably do matter to you. So trademarks protect branding elements, logos and slogans and taglines and product names and company names and all that stuff. If you look down here in the bottom left corner of my presentation, you'll see my logo down here, my name, Pixel Law, with a little circle R. The circle R is an indication that I've obtained a federal trademark registration. So if somebody else starts a law firm tomorrow and calls it Pixel Law, or even Pixel Legal, I could go after them for trademark infringement and probably stop them from using that name. But if you wanted to start an airline and call it Pixel Law, no idea why you would do that, but let's just say you did, I probably couldn't stop you. Airlines and law firms are totally separate. They're not the same. So think about Delta Airlines and Delta Faucets. They're different. They offer different services. So they're both allowed to use the name Delta, because there's probably not going to be any consumer confusion. So the reason I say trademarks might matter to you is if you're operating a freelance business, you probably have your own trademark and you might want to register it with the trademark office. But it also matters to you because if you're helping your clients create trademarks, whether it's business names or logos, you should be thinking about how the trademark plays into it. And you might want to recommend that they do trademark searches on their name. You don't want to accept liability for that, but you might want to recommend that they take some legal steps to protect their trademarks. Okay. Copyrights, though, are the most important. That's where I'm going to spend most of my time here today. So a copyright will protect creative works. This is art, music, dance, movies, film, all that creative stuff. But it also includes other creative things like business plans, presentations, computer code, so HTML, CSS, all that stuff. To the extent you create something original, you can protect it with a copyright. Now, the biggest question that really comes up in the context of creative professionals and copyright is who owns the copyright. And if you've ever seen me talk about these issues before, I'm going to say the same thing I always say, which is if there's only one thing you take away from this talk as a creative professional, it's probably who owns the copyright, because what you're creating as a creative professional is almost certainly copyrightable, and getting the ownership right is critical. So let's talk about how that works. And this is literally part of the agreement itself. So in the client agreement, so this is when a client hires you to do work, you've got three basic options. One is you own everything. You own the deliverables and you own the intellectual property. And when I say IP in this context, that expressly includes copyright. So you own everything and you just give them a license to use it. A good example of this is photographers. The photography industry, or more so the photographers in the industry, have done a very good job at making the industry standard that the photographer owns the works they create, and then they license it to their clients to use it. I actually don't know how photographers pulled this off, but it's really good for photographers because they own all of their works. They control how the works get used, how they get printed, how they get used in magazines or ads or competitions or whatever. The client can't do anything with the photos except to the extent they're given permission in a client agreement or some kind of a copyright license or something like that, right? But for most other professionals, like website designers and stuff, they usually transfer copyright to their client. So that's example number two. In that case, the client owns everything, the deliverables and the copyright to them. So once the client owns it, you, the creator, cannot use it anymore. You can't put it in your portfolio. You can't use it in your marketing or any of that stuff unless you get the client to consent to that use. So normally in the client agreement, you would have a provision that gives you that kind of a permission. So those are kind of like the two extreme examples. But what I normally see is this kind of middle option, which is option number three there, which is you own the underlying assets and the client owns the specific works that you create for that client. So again, coming back to the website development example, just because it's so easy, you might build 5 WordPress themes that you use with all of your clients. Those are your underlying assets. You can't give ownership to your client. If you give ownership of website theme number 1 to a client, guess what? You can't use it again for future clients. You no longer own it. So it's important that you make it clear in the agreement that you own the underlying assets that you use for your own benefit and the benefit of your other clients. And then transfer only the specific works you created for those clients. So if you write bios or if you make a really unique homepage, those you can transfer over. But the underlying assets you retain ownership of. So that's how you work in the client agreement, when your client is paying you to do something for them. Let's flip it though and think about what happens when you hire a contractor. You, in my opinion, should more or less own everything that contractor makes. Now, the contractor might come back and say, well, wait a second, I can't give you ownership of the themes that I've made because I use them with all of my clients. And okay, fine. You can negotiate that third option there for your contractor agreements if you want to. Just make sure that it aligns with your client agreement. If your client gets option 2, where the client owns everything you give them, and you hire a subcontractor and the subcontractor is using option 3 with you, well, guess what? The subcontractor owns the website theme, but the client, according to your agreement, gets everything you're giving them. So there's a disconnect between those two agreements. So you just have to make sure it always aligns with one another. I think that's all I've got on this one. But I see some more questions coming in, so I'm going to take a look at those. Okay, somebody asked about confidential information. I will come back to that because I think that's actually in the next slide. Where do we start if we want to protect branding and we haven't trademarked anything? Good question. Trademark rights stem from the first person to use a trademark in commerce. So you don't actually have to register anything with the government. However, there are a ton of benefits to getting a federal trademark registration. You can also get a state trademark registration, but I generally, I kind of don't care about those. I mean, I do, but the practical reality is what you should do is go to the trademark office website, the federal trademark. That's the United States Patent and Trademark Office, uspto.gov. Go there and register your trademark. It's kind of a confusing process. I recommend you work with an attorney on that. Anybody who knows me knows that I often say, you don't have to use a lawyer for everything, but trademarks are complex, and it takes almost a year to get a response from the trademark office. So I usually recommend you work with a lawyer to do that. How to handle participate who asked during the training to have the PowerPoint presentation material. Oh, I see. So, for example, I'm going to distribute these slides to everybody when we get done here. But these slides I do this for fun and kind of do it for marketing, right? I don't sell these. I don't charge to speak. So, like, I'll give these slides to people freely, and they can kind of do whatever they want. I prefer they not use them to market their own law firm, like if they were to strip off Pixel Law and put their name down there. But point being, I don't really care. But if you're in the business of selling your presentations and your slides, if you're in the business of giving speeches for income, and you don't want other people to use them, just make it very clear. In fact, what you could do is down here in the footer, put a copyright notice that says copyright, the year you make it, and your business name. And then just make it very clear, maybe using a disclaimer slide, that people that are watching it cannot take it and use it for any other purpose, right? Technically, if you take my slides and use them, that's copyright infringement, and I can come after you. I'm probably not going to, just realistically. But if you're in the business of doing that, it's probably a good idea to put that disclaimer and notice on there and tell people they can't use it for other purposes. Let's see here. How do you use trademarks like NFL teams on creative works without being penalized? How do you get permission? Okay, first, don't use NFL trademarks or logos on your goods and services unless you get permission from the NFL. The NFL has very specialized companies that deal with licensing IP. I don't know a lot about it. I just know it exists. You just need to look up like the NFL licensing companies and reach out to them. They're very stringent about who they give those rights to. All right, let's see here. Oh, good question from Carol. If you use AI to create an image that you use on a project, can you give it to the client? To the extent you own the copyright in the AI creation, sure, you can transfer it to the client. The question is, do you own the copyright to the AI created work? I have been lucky enough to go to presentations by the Copyright Office where they have said that they will not grant copyright ownership of AI generated artwork because there's no human authorship. And then I was also lucky that last night I got to meet the guy that created the artwork that won the Colorado State Fair, who applied for copyright for his artwork and was denied because the Copyright Office said that there was no human authorship behind it. And they're fighting that in court right now. So my point is, I don't know who owns copyright of AI generated works, but I can say if you own it, sure, you can transfer it to your client. If you're going to use AI in your contracts, this is something new that I've been dealing with lately. Put something in your agreement about your use of AI. In particular, say you don't represent, which is a promise, that you own the works coming out of the AI machine, because you simply don't know. And if you give your client works created by AI and it turns out that they can't own it because nobody can own it, your client might sue you if you made a promise to them that everything you're making is something that you own. So good one. There's like the Wild West when it comes to AI stuff right now. Okay, I need to keep moving forward if I'm going to get through everything. Oh, I forgot about the provision. I'm not going to talk through this too much. Why don't you just screenshot it? But this is that middle ground approach that I mentioned, where the client owns the unique works created by you, but you retain ownership of the underlying provision. So screenshot this, read through it later. If it works for you, use it. If you're using it in a contractor agreement, so somebody you hire, you might need to flip the words around, right? So the parties intend for you to own it. Just depends on how you define the two different parties. All right. Confidentiality. Somebody asked about this, and this is where I'm going to address this. So most client and subcontractor agreements are going to contain some kind of confidentiality provision. You can sign a standalone NDA if you want to, a non-disclosure agreement. But what I prefer is that you just put it in the client agreement itself. I think it's just easier and cleaner. When you do that, there's a few different things you need to be thinking about. First, is the provision unilateral or mutual? Does it apply to both sides or just one side, right? If you're signing a client agreement, maybe the client says you need to protect their info, but maybe they don't have to protect your info. In that case, it's unilateral. But if you want them to protect your info and you're going to protect their info, it's mutual. So just make sure you understand which way it goes. Next up is the obligations. So you've got protect, don't use, and don't disclose. Protect means you will protect their information. So you won't just leave it on a coffee shop table. Don't use it means you won't use it without their authorized permission. So you can't resell it. You can't give it to other clients and so on. And then don't disclose it. Same idea. You won't tell it to other people. right? But there's also usually exceptions to those policies or those obligations. The exceptions are things like um, if you have to disclose it to a court, then you're allowed to do so. There's also usually an exception that you can disclose it to your employees and subcontractors, but usually that exception is tied to an obligation on behalf of that other party that they have to have signed a non-disclosure agreement with you to protect the information. The idea is you've had these rules that you can't do these certain things, but then there's always a few exceptions that are called out in the agreement. Next up, you have what is deemed confidential, and you can define that very narrowly and say just these 3 things or 5 things or whatever. What I usually prefer to do is have an open-ended, kind of a broader approach that says anything that a reasonable person would consider confidential under the circumstances. And that kind of gets back to the topic earlier. I mentioned vagueness. It's a little bit vague, but I've qualified a lot of those words. A reasonable person. So not just any person, but a reasonable person under the circumstances, right? That's another qualifier. So I like that broad approach just because I don't like to limit it to a defined set number of things. But then you also have exceptions to that too. Those exceptions are going to be things like, things that are in the public domain, things that become public through no fault of you. Those are usually deemed exceptions to the duty of or the definition of confidential. And then last, we have the length of the obligation. So how long do they last? Usually it's like the term of the agreement for 5 or sometimes 10 years thereafter. Sometimes I see that it goes on forever, perpetual. That's sometimes okay, sometimes not okay. It really depends on on your unique situation. I think that's all I have on confidentiality. There's some other questions that are coming in from different sections. I'm going to try to bounce back to those at the end. Here's one about NDAs. Can I tell my significant other confidential information, or should I have her sign an NDA with me? Good question. I have a client right now that's trying to buy a medical practice, and of course, my client wants to disclose all the information to her husband. It's a big purchase, right? And so what we did was in the NDA with the medical practice that she's trying to buy, is we included a provision that says that she can disclose it to her professional advisors like lawyers and accountants, but that she can also disclose it to her husband. And we actually named that person in there. The medical practice could have said, okay, fine, we want him to also sign an NDA. In that case, they didn't do it, but they could have. But no, you can't disclose it to anybody unless the agreement says you can disclose it to them. So just be really careful about how that works. I mean, I think in the real world, people disclose things to their spouses all the time. I'm not saying it's right. I'm just saying that's just how it normally works. Okay, what happens if you have an obligation to protect someone's data, but your computer is hacked? Are you liable? Yes, absolutely. Take me as an example. I'm a lawyer. I have a duty of confidentiality to my clients under my ethical rules. If I am sloppy and I set my Dropbox password to password and somebody hacks into my system, yeah, that's my fault. I should not have allowed that to happen. So of course I would be liable to my client for that. So that's when you can buy insurance. Insurance can help you protect against some of this stuff. And you can buy cyber liability insurance. In fact, I do. I maintain malpractice insurance in case I provide bad advice to a client. But I also include in my coverage cyber liability to cover me in those cases of breach. So if I am hacked, my insurance will cover me, which is really important. Okay, let's keep moving forward. I've got about 15 minutes left. The next important provision that you're going to want to think about is non-solicitation. So I want to mention that a non-solicitation is not the same thing as a non-compete. A non-compete is a provision in an agreement that literally prohibits you from competing with the other party. So if you work in a dentist office and you sign a non-compete, you can't provide dentist services to anybody within 5 or 10, 25 miles from that office. And it's usually limited to like a year, right? That's not what this is. Non-solicitations are much more narrow. And when you're a creative professional, there's 2 things or 2 sides that you're going to want to think about. First is a non-solicitation to stop your clients from poaching your workers. So let's go back to my example of Julie. I hope she doesn't care that I'm picking on her. Julie is my copywriter. I'm making a website for my client. In my client agreement, I will have a provision that says client is not allowed to solicit or hire my employees or contractors during the term of the agreement and for 1 year thereafter. So I might have a team of 15 or 20 freelancers that help me on different projects, right? I don't want my clients going around me and hiring them. I've built up those relationships. I've built up all that stuff and how it works. I want to protect that. The other side to that is I'm going to have an agreement with Julie on this side, right? The subcontractor agreement. My agreement with Julie is going to say, hey, Julie, you're not allowed to provide services directly to my clients without going through me during the term of our agreement and for 1 year thereafter. Now, you don't have to do this, but the problem is if you don't do this, then Julie could just go straight to your client. You might lose that entire line of work. Maybe you like this, maybe you don't. Maybe your client likes this, maybe they don't. Like this is always negotiable. The length of time is negotiable. How you define clients or prospects is negotiable. But the idea is you want to have something in there to make sure that you're not losing your entire business because your client just goes around and hires your contractor without going through you. And again, that's different from a non-compete. It's much more limited. All right. I think this is the last topic. So term and termination. Okay. Two things. First, term of the agreement, which is point one there. So do you need to set an expiration date for the agreement? This is usually the term of the agreement. So going all the way back to one of the first slides, I talked about having the MSA and SOW format. And I recommend you use that almost all the time. It's a really good format. So in that format, you'll usually set the term of the MSA for like 1 to 5 years. I'd say 2 to 3 years is the most common. The idea is the MSA will run for 2 years. And any SOW you sign in that 2-year window is subject to that MSA. If you sign an SOW on like day 700 of that 2-year term, no, that doesn't work. Day 600 of that 2-year MSA, that SOW, even if it goes on for another year, is still going to remain subject to the MSA, even though the MSA expired. Well, I say that you want to make sure your agreement says that, actually. That's how I always draft them, because I want every SOW signed during that period of time to be valid and subject to the MSA. But so say you sign a 2-year MSA with a client and you sign a 6-month SOW, and at the end of the SOW, they don't hire you again. Well, the MSA can just keep running for another 18 months, and that's fine. Or you can terminate it if you want to, but it'll eventually expire. So I like the idea of having expiration dates. I don't like the idea of having perpetual agreements that last forever, at least usually. Usually, I want that expiration date, because if you have a perpetual agreement, it's usually only you can usually only terminate it pursuant to the terms in the agreement. And I don't want you to forget about terminating it. So let's say you have an agreement with somebody that has like these non-solicitation obligations. I don't want those going on forever, especially if you're not working together. So that's why I like to have some kind of a term and an expiration date. Okay, next up, you've got, can either side terminate early? So can you just voluntarily say, hey, client, I don't like you anymore. I want to cancel. Or, hey, Julie, I'm tired of working with you. I quit, or I'm firing you, right? Maybe, but usually there's like a 30-day notice provision. If you have that voluntary termination right, it's usually tied to like a 30-day notice where it says, Julie, I could terminate anytime by giving you 30 days notice. If I'm Julie, and if I'm really relying on the income from Chris, from me, well, maybe 30 days is okay. Maybe I say, well, okay, that's fine, but I want 60 days. Or maybe it's a 6-month agreement and you say, it's just 6 months. Let's just commit to the 6 months. You can't voluntarily terminate early. Right. And then also by the other side, can they terminate early? And if so, what notice is required? Usually if 30 days is required on one side, it's usually required on the other. But sometimes you never have early termination rights. Sometimes, like for a short-term agreement or a short-term SOW, 6 months, nobody can terminate early. It's just 6 months. I'm hiring you and I expect you to get the job done, right? I don't want you to quit halfway through. In those scenarios, you probably at least want to have that breach and cure provision. So a breach and cure provision says that if one party breaches, the other party can give them notice and say, hey, you're in breach. You have 10 days or 15 days to cure that breach, to fix it. And if you don't fix it in that 10 or 15-day window, then I can terminate immediately and we walk away. And this is really important for both sides. So going back to Julie again, if Julie's just not doing her job, I give her notice. She has 10 days to catch up. If she doesn't catch up, I can terminate right then and there. Conversely, I'm not paying Julie. I just haven't been paying her for whatever reason. Julie can then give me that notice and say, Chris, you're in breach. You haven't paid me. You're 30 days past due. If I don't catch up and pay her within the 10 or 15-day window, then she can terminate and walk away, right? That breach and cure termination right, I think should be in almost every agreement. And this is what it looks like. Uh, yeah, this is all three of them. So, well, kind of all three. The first sentence is just a clarity sentence. This agreement cannot be terminated early except as provided in this agreement. It's just kind of an overriding provision. Then you've got either party can terminate this agreement by providing the other party with at least 30 days notice, right? That's either party. If you want to make it one way or the other, you could say client may terminate, right? Or contractor can terminate. And then here's the breach and cure provision that I was talking about. And this is the one I say you should put in almost every agreement. Either party can terminate early if the other party's in breach and they fail to cure the breach within 10 days. So just screenshot these, revisit them later if you want to use them in your agreement. Okay, that's all that I've got. I've got about 8 minutes to go. I've got some more questions in here I can get to. You can find me on LinkedIn, Twitter, and Instagram at The Pixel Lawyer. And you can, of course, email me at chris@pixellaw.com. So feel free to reach out anytime if you have questions. I'll leave those up here for another few minutes while I get back to some of these questions. Okay, somebody asked about the non-solicitation. So let's see. Okay, somebody asked about like, this kind of a question about how long does the non-solicitation last, and does it last beyond when they work for you? And that's up to you in the agreement. So if I hire a contractor and I have a non-solicitation that says my contractor cannot solicit or work for my clients, what I want is a provision that explains how long that obligation lasts. So it's usually going to be the term of the agreement, which again is why you may not want a perpetual agreement. So if the agreement's 2 years, then during that 2 year period, the contractor cannot solicit your clients. But then I usually tack on like one extra year. So a non-solicitation, most states will enforce them for 6 months to 2 years. That's kind of the window, with 1 year kind of being the norm. But I should also call out that some states simply ban non-competes altogether, or in most situations, and some states go further and even ban non-solicitations. These are states like California that have much more strict laws about these things. But Kansas and Missouri generally will enforce non-competes and non-solicitations as long as they're reasonable. So you really can't go to your contractor and say, you can't solicit my clients for 20 years. There's really no reason to do that, right? But 1 year is almost always going to work after the agreement expires. All right, keep the questions coming. I'm going to scroll back up because there are some questions from the very beginning that I actually haven't addressed yet. How serious is it to have my artist to carry insurance on their artwork? So insurance is your first line of defense. Anytime you hire somebody to build something for you, to create something for you, if you can require them to maintain insurance, it's a good idea to do so. But I will tell you, a lot of freelancers don't have insurance. And so it's not always possible to do that. And if you require them to have insurance, they might increase the rate that they charge you. So it's really about assessing the risk. If somebody's going to build you a custom backend system where you're going to store all of your clients' social security numbers, make them have insurance. Put it in your contract that the contractor has to have insurance. And you should probably have insurance too. If somebody's going to make you a backdrop that you're going to use on a presentation like this one here, right? This is just a stock image, but like if I hire somebody to do that, that risk is so low. What are the odds that somebody's going to sue me over it? I'm probably not going to make the contractor have insurance. So it really just depends on the actual risk that you have in that situation. All right, let's see if I can get to some more of these questions here. Here's a question about trademarks. I think I may have answered this kind of earlier. Trademarks protect brand names and branding elements, whereas copyrights protect creative work. So it's a mixture of both. The more valuable the work is to you, the more likely it is that you should protect it with copyright or trademark. Like for me, I've never registered the copyright in this presentation. I don't even have a copyright notice on it because I'm not in the business of selling this presentation. If you steal it from me and use it, yeah, I'll be mad, but it's not going to bankrupt me. But if you're in the business of selling presentations or speeches or whatever the line of work is, then yeah, you should probably register those works because you don't want somebody ripping you off and stealing them. Okay, what else do we have? Can you speak to the use of random images you might find on the internet? That's a great question. Is it free use? No, it is not free use. Years ago, I had a marketing person get an image off Google and gave it to my old law firm for us to use in our blog. And we got a cease and desist letter from Getty Images and said, you're using our copyrighted photo and you owe us $800. And I reached out to our marketing person and I'm like, hey, what's going on here? Can you give us your license? And she said, well, no, I found it on the internet. And it doesn't work like that. Just because you find an image on the internet does not mean that you can freely use it. You definitely need to get a license to use the image. You should kind of assume that most stuff on the internet is protected by somebody somewhere. So if you want to use images, use a stock photo company or take your own images. You could do that too. But you should not assume that anything on the internet is free to use or that fair use would apply to you. What are the legal recommendations for using insights from books and presentations? For example, if a speaker modifies a method or process outlined in a book, is it enough to acknowledge them? So I should start out by saying copyright does not protect ideas, generic ideas. If you want to make a presentation and teach people about the 3 different ways you can assign a copyright to a client, you can do that. I can't stop you. I don't own that idea. I do own my specific presentation. So if you screenshot this and put it in your presentation, that's technically copyright infringement. I could probably come after you. Whether or not I would or not, I don't know. But the more of their expression that you copy, the more likely you're committing copyright infringement. If you take one sentence out of a 1,000-page book and put it in your presentation, under a very technical reading, that might be copyright infringement, but it's probably not. It's probably fair use. It's so de minimis that it's probably not going to cause any problems, and you can probably use it. If you're going to take their entire book and reproduce it in a PDF and sell it on the internet, yeah, that's copyright infringement. You just took their entire book and you're reselling it, right? So you really have to assess how much are you using and how much harm are you doing to the other side. And then getting back to the thing I've said a few times already, you really have to consider the overall risk. If you're copying the Harry Potter book series, you can expect to get a cease and desist letter. If you copy this presentation, I might come after you if you really annoy me, but I'm probably not going to mess with it, right? All right, so that's that question. If you want to copyright something, do you need a lawyer, and how simple is it? Okay, I'm going to make this my last question, I think, because of just timing. You could totally copyright stuff yourself. You don't have to. The moment you create a creative work in a tangible format, you will get what's kind of called common law copyright in that work. But you can register it, and you probably should register it if it's a core aspect or part of your business. And you can do that at the Copyright Office website. It's just copyright.gov. You actually don't need a lawyer for this. I mentioned earlier you should use a lawyer to file trademark applications. I don't really think you need a lawyer to file your copyright registrations. You can hire one, and I could help you. But it's a lot easier. When you're filing copyright, you're just saying, hey, here's my copy. Here's when I created it. Here's my name and address. And you click submit, you pay your fee, and it usually gets approved. It's a lot easier than filing a trademark. So I'd say you can do that on your own. If you have any questions or concerns, of course, you can reach out to a lawyer. But if you're in the line of work where the creative asset is the primary thing you sell. So again, getting back to Harry Potter books, they copyright every single book because that is literally what they do for a living. They sell books. So of course they're going to copyright every book that they write. Whereas I give this presentation just kind of as part of my work, but it's not my core line of business. So I'm not going to bother copyrighting this. It's just not worth it for me. It's not even worth the fee. It's like, I think it's $55. It's not even worth it for me to do that. So, okay. I think we're out of time now. It's 10 o'clock where I am, 11 o'clock where you are. I just want to say thank you so much for joining me. I wish I could be there in person. I really prefer talking in person more so than doing it here. But if you have any questions at all, reach out via LinkedIn or email me, and I'd be happy to see if I can help you. And that's all that I've got. So good luck and have fun for the rest of the Global Entrepreneurship Week. Thanks, everybody.